I grew up in the South when the Civil Rights era came and the Civil Rights laws were passed. After the passage of the Civil Rights Act, I ran a real estate brokerage company and saw through the transition to fair housing from housing discrimination. I understand the ramifications of the Civil Rights Act, and I am proud and appreciative of what it has helped us to accomplish. The 180 statute of limitations applies to every facet of that act. It applies to housing discrimination, and obviously in this case, it applied to employment and pay discrimination. Obviously, with the votes that have taken place and the failure of the Hutchinson Amendment, it's pretty obvious which direction the bill's going. So it's time we ask ourselves one question. Is it fair to reach back to the 1960s, repeal a statute of limitations that applied for over 45 years, and open up the possibility of a plethora of cases that haven't been filed from now being filed? Or, ask another way, is it fair after a game has been played to change the rules in order to change the outcome? Practically speaking, I would submit to you that this bill should be prospective and not reach back. It should say in the future that all the provisions apply to any case that may be filed on a future incident of discrimination. But to reach back without limitation and repeal the 180 days changes the rules of the game, changes the law under which people were trying to operate and running their business. But most importantly of all, Madam President, let me tell you what it specifically does. I ran a company for 22 years. I am very familiar with what lawyers can do in terms of bringing in an alleged case, filing a case, taking you into depositions, and then saying, you know, we can put a stop to all this if you'll just settle for $5,000 or $10,000 or $15,000. It's using an opportunity open to them to intimidate or, in some cases, extort, in my judgment, a fee out of a unwitting and unwilling business. So I just ask the fairness question. Is it right to go back to the inception of the civil rights laws, take an established principle that applied to housing, pay, employment of 180 days, and change the rules so people can reach back after the passage of this and create new litigation under changed rules? In the interest of fairness, I would submit that it should be prospective, that all the application of the law should begin with the passage of the law and its enactment. And I'll be glad to yield the floor to the distinguished chairman who's managing the bill and urge the passage of the Isakson Amendment.